Well, hello, everyone. My name's Eric Whalen, and this is How to Read a Contract, Boilerplate Edition. Um, I'm a California attorney who represents professionals in the board game industry, and I thought as my public service that I could provide the community, I would just sit here for an hour and read through the boring bits that usually are at the bottom half of the contract. That by the time you stop sort of reading, paying attention, and I thought I would just read out that text so that we could all say together that hey, even if we don't read this every week, every day, that we see this, whether talking to iTunes, um, your publisher, one of your artists, you at least can go, oh, Eric talked about this one day in October. I think I'm all right. Um, Boilerplate is sort of there are legal terms in a contract that don't change often. They're pretty much stamped from one contract to the next, and once you've read one of them, you can reliably say you've read them all, though you should still in case someone's doing some funny business. But most of the times, if you at least understand one, you should know it should allow you to ethically skim these sections. So, what's an example? Let me start with a. There's usually a section called the entire agreement. It is just something that says, this agreement contains the entire agreement of the parties and supersedes any prior written or oral agreements between parties with respect to the subject matter thereof. And that just means that everything in the contract will be everything about the deal. There's nothing else. No one needs to refer to any other emails. No one needs to, read the runes or refer to other playbooks in order to understand how this deal is supposed to go through. You're supposed to look at this one document and you'll know everything. Pretty nice. Why it's important to be aware that it's in the contract is that throughout the year, many of you, if you're my clients or people who've signed with them, will go, oh, that doesn't need to be in the contract. We have a previous understanding through emails that they would never do that. Don't worry about what it says in the contract, they say, and that term right there shuts that all down. And so it's important to know that it exists, and it's 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 those types of terms that you just need to be sort of aware of, so you're not making assumptions that you can do whatever is said informally outside of the contracts. Um, Let me find another thing. Here's one that's on a lot of them. No waiver of any provision of this agreement by either party shall be deemed a waiver of the same or any other provision hereof with respect to or other similar events or facts arising at a later time. That's a mouthful. What it's saying is, let's say you are supposed to turn in a piece of art on a particular day, and you're running late, and the publisher says, "Don't worry, it's fine. Just don't do it again." This agreement, the no waiver, is saying that okay, they forgave me this one time, but they can hold me accountable all future times. Not holding me accountable once to a due date isn't going to be a free pass when they're expecting the art and the Kickstarter's launching and they need the stuff. Um, it Now it has other applications. You can imagine that you know as you're doing a deal with whatever you're doing, whether it's text or whether you're the publisher interacting with your distributor. There are other issues where just know that you are reserving the right to hold someone accountable to the term of the contract throughout the duration of the contract, even if you say the first time, like, it's all right, we can ignore that this one time. And that's nice. To make sure that I'm not just chatting to the breeze, are there any questions with that? Anyone have any confusion? Is this all sounding like stuff everyone knows? And, you know, taking a moment here to go, like, what were you expecting out of this panel, if not for me to continue just going down the really boring boilerplate? Boop, boop. Check in chat. Anyone alive? Well, you're following. Great. Then I'll continue to the next one. Just know that this is not meant as a lecture series. This is very much us here together. And if you guys go, no, we get all this. Like, yeah, contract is the contract, nothing else. You're exactly right, Trey. But yeah, and if all this sounds really boring and like really self-explanatory, I'll just keep going through, or if you have other legal questions, I won't give you legal advice, but like, feel free to jump in. At the Medtopia in person, we'd all be sitting around a room, talking, having fun, just making sure everyone understands the law to this that couples with this hobby we all love. So, with that said, and waiting for anyone else to say anything, how about this? All fees payable hereunder are expressly contingent on owner's execution of this agreement and completion of the standard payroll, startup forms, including but not limited to satisfaction of the requirement of applicable laws, if any. So you'd see one of these terms. It's found in most of them. It's if you don't follow all the laws and all the procedures to document your process and do the job responsibly, you're not going to get paid. It's important to be aware when you're going, I shipped, wholesaler 300 copies of my game. When am I getting paid? Or when are they going to get back to me? When are any of these things? And if they have something there and you forgot to, make sure to, I don't know, fill out your VAT forms in time or correctly, then you might not receive anything. So that's also a good reminder to say, make sure you're reading the entire contract and every letter, email you're getting back and forth between the other party. And if they are, if you are a publisher and dealing with other parties in your distribution chain, there are some important things, and there are terms that you can put in contracts to stop payments from being made unless every little bit of procedure is followed. What else? Oh, this one's good. So this is the there's one term called the severability term, and it'll read something like this. Yeah, completion is doing work there. So what defines that list? List of what? You got it, Trey. Come on, tell. So completion. Trey says completion is doing work there. So what defines that list? What list? Oh, what defines completion? So it'll be whatever in the rest of the contract. So what we're talking about here, all of these miscellaneous terms that usually make up legal boilerplate text, happens in like the very bottom, the very last sections of the contract. And so this is all referring to a document that happened in a previous episode, which we are not covering by this panel. There's the sections where it says here are the deliverables, Exactly. So it'll talk about the deliverables and when they're supposed to be delivered by, and the payment to the parties, and you know, obligations of each party. And so, but then at the end of the document, you can put something that says no one gets paid until all of the procedures are actually followed through on. Which can be different. There are so in the deliverables section, you might see something that says, you know, artist. I'm thinking artist contracts because there's a lot of art being being dealt with in the board game industry. So between like an artist and a designer, it may say something like, "Oh, artist agrees to deliver the work and give us a certain amount of revisions and do, you know, X, Y, and Z to make sure they're giving us a piece that we can use." And then there'll be a term next that says, you know, company, publisher, designer has 30 days to pay the publisher, to pay the artist for their work. And it can say that. And what the terms will do is they'll have the designer, the person who commissioned the work will have those 30 days, but if they hit the end of those 30 days and the artist is going, you know, it's time for you to pay up, the designer can still say, "Whoa, you haven't given me proof that you've registered this copyright with the US Library of Congress," or "Whoa, you didn't you know, provide what credit I need to give you in order for me to make this actually usable. You didn't give me this assurance or this piece." And
So Eric, just hold tight. Pause for a second.
oh, I'm back. Thank goodness. Oh, maybe not. Well, Trey thinks I'm back, which is fine.
You're back. You're
Okay,
back.
I'm good. Hallelujah. Who among us is a good Who among us is good? This is amazing. I keep thinking of that wonderful dog comic. Wonderful. You see and hear me. I answered your question. Fantastic. Let's go to the next bit. We're eating the legal vegetables. There'll be other panels talking about what you should be fairly paid and how many rights of reversion you have. There are a lot of wonderful artists who either have had panels earlier this weekend or will have panels maybe that talk about all the wonderful stuff that happens before this miscellaneous section full of the really dry stuff. But here we are, just making sure that we've all read through and suffered through these at least once. As I sort of said, well, as I said in sort of the lead up advertisements for this, many lawyers do forget to read their boilerplate text. They go, "Oh, this should be in a standard contract." Um, I will put it at the end, and it is something that has happened to many people I've worked with and myself on actually two occasions that have scarred me for the rest of my career. Where, um, oh, let's just go to that here. Let me give you an example of the one that I see, and it's called the a choice of law and choice of forum clause. So it's going to read something like this. Um, and yes, that was a great recovery, Dexboard. Um, this agreement shall be governed and construed in accordance with the laws of the state of, and in this case it says Texas. The parties hereto hereby agree that the appropriate and convenient forum and venue for any dispute between any of the parties hereto arising out of this agreement shall be in the courts of Dallas, Texas. Dallas County, Texas. And each of the parties hereby submits to the personal jurisdiction of any such court. The foregoing shall not be limited the foregoing shall not limit the rights of any party to obtain execution of judgment in any other jurisdiction. Can you imagine the common problem that happens when you copy and paste this between documents? Anyone in chat? Give you 10 seconds. If your answer was, this would really suck if you just copy and paste this into a into a contract that none of the parties involved were involved in Texas, someone in California and someone in Maryland, well, they'll look at you or they'll look across at each other and go, why are we doing, if we have a dispute, why do we all need to go get hotel rooms in Texas? Why do we need to get Texan lawyers? Let's check with our let's check with our legal representatives why they are suggesting that we go to some random and far-flung state that has no actual relevance to this deal. And that is a trap that lawyers get caught in all the time when they try to be efficient and try to recycle words, not reinvent the wheel, and accidentally send their client to the shadow. I mean, Texas. Yes, and then, well, uh, middle ground. I'll get to that in a second. I'm assuming Dallas is the location of the company that is party to the agreement. Yes, the first time that boilerplate was drafted, Dallas was the location of the company that at least did the deal. Who was the party with enough negotiation clout to say we're doing this in Texas if anything goes wrong. Usually whoever drafts the contract will decide where everyone's going to end up if there's a problem with it. It's sort of by their right, and as person who spent the money to get this contract written in the first place, that they get to choose where the final battleground is if everyone can't make up their minds on interpreting things. So with the middle ground, if it's between two, so the idea would be going to the previous example I used of one party in Los Angeles and one part California and one party in Maryland. I'm not entirely as familiar with all the city names there. Sorry, Maryland. But wouldn't it be great if you could just choose someplace in the middle? The difficulty with that is that one, the person writing the contract is going to fight you on that and say, no, we're spending the lawyer money up front. The least you can do is come to the where we want to do this final. Baltimore, Chevy Chase, Maryland. Trey, I'm going to give you I'm giving you so much faith that those are actually Bethesda. Yeah, any of those. You two could just make up random city names, and I'll believe you. That I surrender myself to the chat in that fashion. But so coming up with a middle ground is hard because often one side will have more negotiation leverage than the other. You will see that sometimes when both parties have leverage and can sort of say, okay, we'll do this somewhere in the middle. It doesn't have to be somewhere in the middle. My favorite one was two parties. Two parties where they were both operating out of Burbank, California, and nearby me. And it said in their agreement that if there was any problems, if they needed to have any litigation done, then the appropriate forum was to litigate this in Hawaii. And that's a fascinating strategy that there's no law against. It makes it so that, one of these years, if they actually do need to go fisticuffs against each other, they can do it on the beach somewhere and write it off as a business tax expense. So, yes, the middle ground, or more broadly, some ground that isn't where either party is located, is an entirely viable strategy, just not one that your client will often choose, and or that you might not often choose, and that your lazy lawyer who did not read the rest of their boilerplate over a final time might accidentally send you if no one's paying attention, least of all the lawyer. Another reason that a middle ground state isn't usually chosen is because the choice of forum clause, the choice of where the courthouse will be, is often paired with another miscellaneous boilerplate term, or a term that's found in the boilerplate. It's so short it shouldn't really be boilerplate, but most of it is, except for the part where it specifies the locations that everyone's going to get sent to. There is a term called the choice of law clause, and it says, okay, when we get to this location that we've chosen to have our duel, we're going to be using the state laws according to this state. And that's usually fine, and it's usually the same place in the contract. It's also important to make sure that where those that the choice of law, the body of law that you've chosen, and the dueling ground courthouse that you've chosen are compatible with one another, because you generally want Californian law interpreted by a Californian court, or Texas law being interpreted by a Texan court, or a Annapolis, Maryland law Maryland, there are no state laws. Well, no, there are state laws. Misspoke. There aren't city laws. There are the. I've gotten on a tangent. You don't want a Maryland law interpreted by a Texan court. That's what you're trying to avoid. And often, Texan courts, when asked to interpret Maryland law, won't do so. They'll say, send it back to this location. So you want to make sure that you're reading your choice of forum and your choice of law clauses to make sure that they are compatible, that they match up, that they are what you expect, and to generally be prepared that that's what's going to happen next, unless you raise some problem with your other party to say, hey, I don't like this, I don't know what to expect. Does that make sense? I know I got tangled up there when I tried to say there weren't any city laws in Annapolis. I'm sure there's at least one parking regulation that has nothing to do with the agreement that you'll be signing, but it still exists. Otherwise, I'll look for the next term in a contract that you could be expected to see. Okay, seems like I can continue. Joint and several liability. If a party to this agreement consists of one or more consists of more than one person or entity, the obligations of such party hereunder shall be joint and several between and among such persons and entities, such that each person or entity shall be fully responsible for such party's full performance of all of its obligations under this agreement. This is making sure that, let's say in a situation, just to vary it up, you're in a situation with a co-designer. The two of you, parties roll and write, are making a game, and they've stolen the idea for their game, from their Euro game from someone else in the industry. Let's just go after all the boogeymen at once. So, Mr. Roll and Ms. Wright have stolen this idea as co-designers, and the person they stole it from sues them for stealing their game design. And they go to court and they're found guilty. This will, the joint and several liability clause will say both parties have to pay for this. It doesn't just go against one or the other, but each party will be held responsible to the degree that they contributed to whatever legal trouble they got into. And that is definitely that. We don't see too many people getting to litigation within the board game industry, but this would be more relevant on a more day-to-day basis if you got into situations where both the publisher and the game designer or an artist were all getting sued together for breaking violating someone's copyright or trademark, and one or more parties wasn't able to really have their hand on the lever to stop the legal problem from happening, the incident from the rights from getting violated, but still did enough to contribute. This anticipates that day and says that on that day, everyone will be held accountable to a certain degree. And that may not be something you want to sign up for if you're paying, if you're only getting paid $75 for your piece of art. There are a lot of copyright situations where the copyright violation, a copyright violation would be a couple $1,000s. It may not make sense. So you want to ask those types of questions, and if you see it, and see what you can do to make sure that you don't regret a small time deal that would have larger consequences depending on how much you're held accountable for certain violations or incidents that could occur. Going to the situation where it's an artist going, oh no, I don't want to be. I see it all the time with the indemnity clauses. A publisher will say, and this is almost boilerplate enough that I should talk about it, is in the warranty and indemnity in the representations warranty indemnity section, which will usually be just above the miscellaneous at the end of the contract. The parties will say that if you violated copyright law, then you indemnify the other party because it's your fault, and vice versa. If something happens while the publisher is taking your art or game design and they throw the McDonald's logo on it and are sued for trademark infringement, the indemnity clause will stop the designer from being held at fault for that. And it keeps parties it keeps a layer of separation between which party's responsible and who's getting hit by the penalty hammer at the end of the day. when you are doing that, it is fine to just, you know, let your eyes glaze over and be and say, okay, I'm willing to take this risk. I'm willing to indemnify you against these problems, even though you're only paying me $75 to participate in this agreement, in this venture. You can do that often because if you know that you didn't do anything wrong, if you know that all of your art is original, your OCs are yours, then there's no risk that you need to worry about. And then by worrying about it, it sends a red flag to the publisher, and sort of like, is everything original here? Is everything unique? Are anyone else's rights being violated? And so, yeah, did that make sense? All of the joint and several liability, and you then the tangent on indemnification clauses, which could easily be its own lecture. Mr. Trey, anybody? Sure that. Well, there are 8 of you out there. Who else is lurking? All right. Well. All right. Okay. That's good. Clap if you believe in fairies or me. No. That's over dramatic. Okay. Any legal questions as well? Wonderful. Thank you, Trey. um, because you two have been consistently talking, what were you hoping to get out of this panel, Trey and Mista? I want to make sure that you two specifically get some value out of this that you were really expecting. What convinced you to give up an hour of time, or at least the last half hour? Like, what nugget of wisdom were you hoping to find, or what projects are you doing? Just tell me. I'll go on to the next thing, so you have some time. But please tell me. I'm personally interested in your life stories now, because I'm also not sure whether I'm going to have anything to talk about in the last 15 to 20 minutes. I'll start handing out, personalized advice to your venture. You can get $50 worth of legal non-advice from me if you stay in for the rest of the program. And if anyone else is out there in cyberspace, you're welcome to join in. We don't just need 2 people in chat. There are supposedly 8 of you, or at least 7. I think I count as one. You're new to all the contract stuff. What are you doing? Are you an artist? Are you a designer? Oh, I don't know Leonard French. I'm going to have to write that down. Plus slightly terrifying. Okay, you'll have to explain that. What's terrifying about this? It's just the law. It's just any of the terms that you see in a contract, I guess, should be mildly terrifying on the other hand. Because while all of these terms are pretty standard, they don't change from contract to contract, which is why they're called boilerplate. They're just stamped on like you would stamp onto iron of a boilerplate. At the same time, anything that's being put into a contract is modifying how the state laws are written by default. Because if something isn't in a contract, state law or federal law supplies the default understanding. So anytime it's put in the contract, it's either affirming that everyone understands the same state law, or it brings their state law into some other state, or it's somehow modifying how some variable that might change based on what state you're in. So let's see. Okay, he's a copyright lawyer on YouTube. That's great. I will check that out later. Attending many panels, but I'm always interested in increasing my legal knowledge. Hardest thing to do for me is originating contracts for projects that are not boilerplate at all. Why are you originating your own contracts? The this is a little flippant and a little you know, self-promoting of me, but hire a lawyer to write your contract so that that you at least have something to go off of as a cookie cutter. And then as soon as you have one contract written for you, you can use all that between contracts and not have the wheel reinvented, and then the whole thing's boilerplate for you. Um, so I don't know if your skill set is art or your skill set is design or publishing, um, then stick. God, the words that come off my hand are stick to your lane, but I mean that in a way more polite and friendly sense, which is the sense of you're an expert at your field. Uh, don't try to do your own research on vaccines? Question mark. I think that's the interpretation I'm going for. But have at it. You're all smart, and from what I've seen, and it'll be all right. We've read and designed or interacted with our share of rules, being board gamers. So but it is still good to at least hire a lawyer for 15 minutes to just look over this. Touch up. Did I make some stupid error? And Mista's just learning contract stuff. Okay. Keep checking up with chat. The game designer who is new, neurodivergent, and poor feel like it's really not geared for regular individuals. That it's not geared for regular individuals. This lecture, or just generally contracts. Because if the lecture isn't really geared for regular individuals, then please help me figure out how. Because if it's not geared for regular individuals, then who is it for? I have to communicate with the law. Oh, contracts. Yeah, no, there are a lot of that is sort of the skill that you will see and you will notice between vendors and publishers or designers who have lawyers that really work in this industry, or lawyers who or they have lawyers that they've imported from related industries like intellectual property general, contract general. I've seen there's a LARP that I am personally involved in where a lot of their legal work was written by a real estate agent, and that is not that is not at all geared for regular individuals. It's not geared. It wasn't geared for me. I had to look up some stuff just because it's like, huh? That's not how people would say things. But you skilled lawyers can write things that are colloquially and plainly understandable. But at the same time, they're just a sort of acknowledging, acknowledging that problem, Alder. It's that lawyers have to straddle a balance between being understandable and being professional enough that you feel like paying them the large amount of money that they charge, because it took a lot of money to get all this knowledge and do 3 to 4 years of education to really come prepared to fight this duel on your behalf. Um, the This panel is definitely me talking as a person because we're in Metatopia, and if when the convention reopens and we're all in person, you'll see that there is this, business casual, speaking that you can get away with. Uh, you know, uh, you still have to be polite and nice and professional, but at the same time, you could say that some of these people shouldn't be, you know, trying to write. Some of these people have not written uh, to be understood. You can be politely. You can talk about things openly. I lost that train of thought, so I'm going to move on. Let's read a term in a boilerplate. We did joint and several liability. We did entire agreement. We did governing law and jurisdiction. You can also change. This is an interesting sample. Oh, I see what it's doing. So arbitration clauses. Arbitration clauses. So yes, your contract might say, "Hi, if you have a problem with us, come at us, fight us in Texas under Texan law, or Maryland under Maryland law." But your contract will often have a similar, a highly related clause in it that says dispute resolution. Any dispute of this agreement between the author and company or any of its officers' employees shall first try to be solved by mediation under the commercial mediation rules of the American Arbitration Association, or the international. There's an international version. It's not in this contract, but it's called the ICC. You'll know that it's the correct one if it goes by that acronym. Before resorting to official arbitration, such rules, if such dispute is not resolved within 30 business days following notice of such dispute by either party to the other party, the unresolved dispute shall be settled by an official arbitration, administered in language of your choice, in location of your choice, by the American Arbitration Association, with the award being final, binding, and non-appealable. Each party shall be entitled to appoint one arbitrator, and the arbitrators so appointed shall designate a third arbitrator. Alternatively, if both parties agree, one neutral arbitrator chosen by the American Arbitration Association can be used instead. Neither party nor arbitrators may disclose the contents or results of any arbitration without prior written consent of the author and company. This agreement to arbitrate shall survive the termination or repudiation of this agreement. Geez, there's a reason we don't read and reread these every time we're talking, is because that's a lot to get through. Does everyone know what arbitration is? I'll give 10 seconds to see if anyone throws it up in chat, but otherwise I will continue after I finish this sentence. So while you will see in courtroom dramas, the two lawyers and their clients go into their boxes, getting ready to duke it out with their words. That's the standard litigation. About 95% of legal disputes, or at least that's what the percentage was back when I was studying, get settled outside of court before it gets to that stage. And they either do that through mediation or arbitration, or, some sort of settlement agreement before it gets to the law and order set. Whereas in a court situation, you have a judge and two lawyers trying to figure everything out for everyone involved. In arbitration, you have, a panel of 1 to 3 retired judges that sort of give their opinions. They look over all the things and they just sort of try to see if they can come up with a solution in a more casual play format. Less of a tournament style, more of your Friday night legal fights. To rip off a Wizards of the Coast Friday Night Magic. And see if they can't come to a solution that makes everyone happy. People like to have arbitration agreements, and lawyers are strongly encouraged to have the arbitration agreements in their contracts in order to make sure that not too much pressure and strain is put on the law and order legal system, and also because arbitration can be faster and more casual to get through, and mediation even a step more rules light, user friendly. See how deep the problem really is to settle out. And in those stages, but when they come before the law and order litigation, you can usually see how the cards are going to fall. You can usually count the points in those stages and go, oh, there's no way I'm going to catch up in this game, or oh, there's no way that this is going to be ruled in my favor. And each segment is usually more expensive than the last. The this is something I only touched upon, or I only started thinking about more leading up to doing this panel, is whether I actually agree that arbitration agreements are good for our industry. For certain parts, yes, definitely. But going back to the $75 picture artist, with arbitration agreements, the amount, in law and order litigation, you usually have to pay $100 to be heard by court, and chances are you're going to be going to a small claims court because the amount in contest that's being contested is, let's say you're an artist and you're not paid by your designer, you're suing this, and let's say it's, let's say it's $7,000, just to make sure it's worth your time to go hunt them down to the ends of the earth and get your money back. $7,500. We'll just add 2 zeros to the original. In that case, in order to get a small claims court appointment, it's like $100, maybe $200 once all the legal fees and registration for the time is put up. In order to get that process going, whereas with mediators and arbitration judges, like mediators can be $200 or $300 an hour, and arbitration judges usually range in like $500 to $750 an hour, and you've hired 3 of them to all fight with each other, which is not going to be done in an hour usually. And then that starts to make less and less sense because you've set up this math problem of $7,500 that you as the artist could possibly be entitled to, minus 750x. That's there's a lot of another application of where you use math in real life. It's when to get a lawyer involved, or when to get an arbitrator involved, or a mediator. It's, set up the equation and see at what point it still makes sense to do all this and engage in the system. But yes, most of the time within the boilerplate section, you are going to be agreeing to an arbitration agreement unless you choose not to, which some people might let you get away with. It depends. You can ask the question. That's always fair. But it's also important to make sure that you're similar to the choice of forum clause. You know where you're going to be getting the hotel to go and show up for this. And in that case, as my bankruptcy law professor would always say, choose Honolulu, Hawaii as the place where the arbitration happens, and then even the arbitration judges might give you a discount if you were that smart. Well, we're at the 10-minute mark. This is wonderful. Okay. Yes, I have psychic voices in my head that tell me when 10 minutes have happened, or 10 minutes are left. Which is fine because I'm running out of material. Does anyone have any questions on arbitration as I go to the next one? Just feel free. or any questions generally. We've hit the last 10 minutes. Is this is there something you were expecting to find in this panel that you didn't otherwise receive? Is there anything I can do you for before we scatter to the winds until next year? Where I'll probably cover the second to last sections of a contract, and just every year I will read contracts from the bottom up until at some point we'll get into how to put to list parties and their addresses up at the very top of the document, or even how to title your contracts to make it so that it's less scary for the people you're dealing with. Yeah, how was yours? How was your panel, Mo? I know you came here halfway through. It was lovely seeing you. Mo and I have been trying to hang out and meet between Metatopias since 2019, and we finally succeeded before this this Metatopia. So make sure that this is a general statement, unrelated to the rest of the panel. Make sure you're networking within the industry with people in your local area, because when we're not able to all get together and have a wonderful time in Morristown, New Jersey, together in person, there are still probably some other people in your neighborhood who are just as interested in board games as you are. And let me see if I can flawlessly transfer the next thing while I don't see any questions still. Da, da, da. Sometimes you'll see a non-disparagement clause in your miscellaneous boilerplate section. It says that, hey, parties will agree not to say that the other person is a shitty brat who should never be worked with again, or whatever the legal equivalent is. I don't have an example of it, so you know, we polish it up. We polish up our words when we need to, and we're being paid. But if you ever see one of those, know that it stops the other party from saying bad things about you. It stops you from saying other bad things about the other party. Um, no, this isn't legal advice, but I generally don't like those, because I think that being able to say things about the other party in public spaces like Twitter is a great use, and having that threat on the table is a great alternative to arbitration agreements. That's my hot take, and I buried it in the last, at minute 53, so that it's hard to clip this and put it around. But yeah, non-disparagement clauses, I'm not a fan. I think they serve a purpose, but you know, negotiate. Negotiate about them. Headings and counterparts. The headings of the sections contained in this agreement are for convenience only and shall not be deemed to control or affect the meaning or construction of any provision of this agreement. This agreement may be executed in two or more counterparts, which taken together shall constitute a single document and be considered the original document. So that's just saying that if I label, section 12, I'm going to give you $1 million for your great game idea that you haven't actually put into an expressible form. And then section 12.1, section 0.1 is, anything else. That heading means nothing if it says so in the miscellaneous. The miscellaneous boilerplate section can specifically say that certain parts of the contract are to be read in a certain order and not necessarily in a way that makes them enforceable. It's one of those weird things that lawyers can do, or your rulebook editors can do when you're making up all the rules as you go. You can make these non-default ways of contract and legal interpretation. Uh, the second part about the counterparts allows for things like DocuSign, or sort of the the digital contracts signing, when one person signs it and then another person's going to sign it later. This is saying that by their powers combined, they can form original document. That's usually helpful in assuming that you're not in a circumstance where everyone can be together in the same room and sign the blood oath under witnesses and all that sort of traditional jazz from a bygone age. Send your notices to the right address. There's a boilerplate usually that says where that, throughout contracts you will generally need to send notices between parties. Make sure you are giving your physical address to anyone you're doing a deal with, because they may need to contact you without your Discord handle. My Discord handle is Whalen hashtag 0184 if you have any questions in the future. I'm sort of noticing that we're in the last 4 to 3 minutes. I'm trying to transition into like, had a lovely time. If there aren't any more questions, I'm just gonna self-promotion plug and maybe check over my stuff one more time. Doing it sort of scattered since I don't have any other panelists I'm needing to outro out with, and tech will cut me off whenever. If you need a lawyer, you can contact me, Eric Whalen, at the S Whalen, spelled WHALEN, at gmail.com. Within the next year, I will have my blog fully published. At the moment, it's in sort of a Metatopia style, playtesting state. And let me get that link and put it in chat. It's not fully populated yet. As this next year comes on, you're going to see more stuff in it. You're going to see that it looks a lot nicer. But if you do need to contact with me and you're fine with prototype lawyer web design, then you can save that link somewhere, and maybe around March, hopefully it'll look better and won't just sort of remind me that I can't be everywhere and do everything while I'm trying to be everywhere and do everything for my clients. Let's see, with 2 minutes left, I'd like to thank chat, Trey, Mista, and Aldercone. I've only been seeing the first half of your name because I've just been sort of I've been speed reading and making sure not to collapse under the pressure of the millions of eyes that could see me, but at least the 6 eyes that are participating in chat. So thank you all for your patience. Are you sure there aren't any questions? Are you sure you've been left enriched? Now's the time to ask the real good questions, because there's probably only about a minute left, and I can get cut off right in the middle of answering your question, which I think would be a hilarious way to end. Because I don't know, we could start talking fair use. Don't believe YouTube when you see that someone says it's fair use. It probably isn't. Or probably no one knows. Let's see. Oh, I think that's it. I think so long until next year. I've been Eric Whalen.